Hello, YouTube. I'm Vince White. I'm an employment attorney, and on this channel, we answer publicly posted questions from YouTube users, getting folks the answers they need from an employment attorney. But not today. Today, we're talking about Mark Cuban and how the director of the EEOC, the Equal Employment Opportunity Commission, vindicated me personally on a one-on-one level. No, not true, but sort of true. A little bit of background here before we get to Mark Cuban. For years, if I recall correctly, the reason I got off Twitter and like a variety of other platforms, including like Reddit or whatever, was because people used to say like, well, it's legal to hire people based solely on race or using race as a criteria. And that's not currently true. That's never been, since the advent of Title VII, that has not been true. And people get really mad about it when I would be like, hey, that's actually very clearly illegal in Title VII. I'm for diversity. Like people get really mad, right? Because I'd be like, hey, listen, for diversity. I think diversity is an incredible reason to, it's an incredible benefit to the employment workspace. Companies would benefit greatly from diversity, and they should have programs aimed at developing and retaining diversity. But you can't use a protected class like race as a criteria in the hiring decision. That is fundamentally going to be illegal under Title VII. And people would say like, Vince, you're a corporate shill, you're a really bad person, you shouldn't say that. And there's some case law over here that says we can go ahead and do this. And you would go and read that case law, and that case law would not say in any way what those people claimed it said, which is kind of common, right? There's a whole bunch of laws that just don't say what people collectively believe they say. Like that's really common. It's so common that like there's situations where like people will quote the holding of a law to you, and you're just like, okay, can you show me where that statute says that? And they're like, what are you talking about? It's like the third paragraph. Yeah, the third paragraph's not about this at all. Like not even a little bit. And it's even more prevalent with case law because case law is not drafted as sometimes as carefully as statutes are. Or at least it's more tortured in the way people use case law. People will extrapolate and go much further afield from case law than they might from a statute in some situations. So, you run into this a lot. And that case law very clearly, did not grant any employer in the United States the ability to use any protected class, including gender, race, any of them. There's no protected class that could be used as a reason to hire or a reason to fire under the federal statute Title VII. Now, people got so angry at me. A person who had literally, like, this is what I do, right? Clearly, I believe in equality in the workplace. Clearly, I believe that workplace discrimination is wrong. I have made a career based on it. And I have every single reason, both sincere and ethical and nefarious and greed based, to want the expansion of anti-discrimination laws and the expansion of diversity, right? That benefits me both in terms of my beliefs and my ethics and my politics, right? But it also benefits me monetarily, economically, right? But people would go pretty crazy on me, being like, oh, you hate minorities, and you can't say this, and you're wrong, and you're a corporate conservative shill, and all these things. And I was just like, okay, like Twitter, X, whatever, there's no value. These are not intelligent human beings, and the people who have time to waste on this platform probably don't have anything going on. And as it turns out, I was right, because apparently they're all bots, right? So, I mean, most of them are. 70%? I don't know. What's the numbers? I don't think there's any real users, as far as I know. There's a few, I guess. Okay, so jump forward like 5, 6, 7 years, whatever it is. Mark Cuban is holding forth on, I think, Twitter or X or whatever, being like, you can hire based on race. And the director of the EEOC, the Equal Employment Opportunity Commission, kind of like ducks in, is like, hey, no, you can't. It's very clear. That has never been the law. That is not the law. You cannot hire. In the same way you can't fire someone because of their race, you can't hire someone because of their race. That is not legal. If you're hiring based on race, you are then harming all the other races, right? Like if you go out and you're like, I want to hire, let's just do national origin, right? Because we always use me as an example to make it easier. I want to hire some Irish American dork. Okay, so now every other national origin besides Irish American has been harmed because they now have less than equal access to that job, right? If there's like a 10% bump for Irish Americans to get a job, I don't even know if I'm Irish American, like just like whatever, right? Like that's like what my family said at one point. But every other group, like if you're Thai American, you're Indian American, you're African American, all the other groups have been harmed in terms of their ability to get this job because this job went out and said, oh yeah, we're looking for an Irish American for this position. That is clearly discrimination. It is still clearly discrimination if you say, you know what, these Irish Americans, we got enough of them. Let's make sure we hire African Americans now. The same thing is true. The same thing is true. You're still committing discrimination against every other group besides African American. Now, the argument for doing this was that, well, African Americans are statistically experiencing a lot of difficulty getting hired into certain roles, and representation matters. And there's a lot of studies. There's a 2004 study that reflects that African American sounding names have less chance to be called for interviews. There's a lot of things going on. There's a lot of really bad things going on in the workplace with racial discrimination, right? So we should be able to do this. And that is a policy goal, and I'm not a policy person, right? I deal with the laws as they are. So that is a strong, I would view that as a policy layperson, as a strong and compelling policy argument. Here's the thing. It's not what the law says. That's something that you could use to inform the next round of drafting of statutes for the laws in this field, right? You could look at these problems and say, yeah, these are significant problems. Maybe we have to change up how we draft this law. But Title VII says what it says. And I don't get to tell you that Title VII says something different because I feel like it should. And all the people for the past 7 years who said that Title VII doesn't say what it absolutely says, and who misuse tortured case law to feed just absolute bullshit to corporate America, those people, if they were attorneys, were committing malpractice. And if they were not attorneys, they're just simple jackasses who didn't know what they were talking about, right? So, like, it's important to note, corporate America, you hired consultants. You hired law firms to guide you in building your diversity and inclusion programs. And many of those consultants pushed you to hire based in part using different protected classes as criteria, right? Now I understand why you did it. You wanted inclusion. You wanted representation. And you were right. Those things are very important. You wanted diversity, and those things are very important. They're important for society, but they're also important because they benefit your company. They are good things, fundamentally. But the way you wrote those policies was likely illegal at the time you did it, and still illegal today under the auspices of Title VII. And the people who told you to write those policies in the way that you did actively misrepresented the law to you, like entirely. Like there was no legal basis. There was fundamentally no legal argument of any merit that they could make to urge you to hire using a protected class as criteria. That can't be done. Right? So, I'm linking the video down below. There's a news story about it. And the news story is, the news part of it is that Mark Cuban, who's a great business person, from my understanding, he did amazing work with the Mavericks, took them from like a $300 million business to like a $4 billion business. I don't even know. Some incredible success, right? Like he did great from what I'm told. But that doesn't make him an expert on Title VII, right? It doesn't make him an expert on employment discrimination. And so he went on the internet, he went tappa, tappa, tappa at his keyboard and said some things on X or Twitter or whatever it was, and those things were just wrong. Now, I understand why he said them. I'm sure that people told him those things were true. It doesn't matter, though. You might be able to sue that person who told you those things for malpractice someday. You might, but it doesn't mean you're not going to get sued, right? Like if you go out there and you say, oh yeah, we have a 20-point preference for X, Y, and Z protected classes. Cool. I like what you're doing there. That's morally and ethically a really great thing to do. It sucks, though, that you breached the federal statutes, and in most states, the state statutes as well, and many locales, the local laws as well. Because that's a lot of claims that you handed to every single applicant who you didn't hire who wasn't a member of one of the X, Y, and Z protected classes that you stated a preference for, right? You've just created hundreds, if not thousands, of claims. And as part of your feel good in the internet endeavors, you created a bunch of evidence to that effect. This is very similar to when IBM, under their old CEO, Ginny, went ahead and created a video about how they were going to hire and elevate younger workers into their workforce, and how the important thing that would save IBM was these younger workers, which was code, of course, for we're going to treat younger workers better, and they're going to get more promotion opportunities, and they'll be more likely to be hired than our workers over 40. And of course, famously, IBM created that video where they excitedly documented their intent to engage in age discrimination, and then faced hundreds, actually I think thousands, of age discrimination claims because they shockingly created, using the very highest levels of their company, they created video evidence about their plan to engage in age discrimination, and then they proceeded to do that for years. And everyone involved in that project surely must have understood that you can't legally have a preference under federal U.S. law for employees under 40 versus employees over 40. They must have understood that. Highest level executives, the CEO of IBM, what rarefied air, right? They must have understood that. But somewhere along the way, they decided to make a video about how they planned to break that law hundreds and then thousands of times. And I'm not calling any of those people stupid in this video. But I am saying that's a bizarre departure from the law. And there was never at any point in that scenario any case law that I'm aware of, certainly, that would have led them to believe they could do that, or they should do that, right? Now, in this video that I'm going to link below, it's a news piece, and Brianna Greyjoy in this piece makes some solid arguments. I believe she might have been the press secretary for the Bernie campaign at one point. Don't quote me on that. She was really high up in the Bernie campaign. I think she was also a public defender in Brooklyn, and I think she went to Harvard or something. Neither of which, being a public defender in Brooklyn and going to Harvard, do not give you points in my book. But being involved in the Bernie campaign is respectable in my mind if you value workers' rights, right? And this guy they have on the channel, on their news channel, whatever, to talk about this is like pretty clearly a tin can in boxing parlance. Like, he doesn't have the capability to make the arguments he's trying to make. Like, he's trying to make policy arguments, and I'm immediately like, whoa. Why are you making policy arguments? The policy is not relevant. The law is the law. Like, there's really, like, Brianna Greyjoy is correct. There are tremendously good policy arguments why you might want to address these laws, because we have lots of problems with this. So please understand that I'm not espousing or underwriting in any way the policy arguments of this guy they have on their news piece. I don't think they were either. I mean, I kind of feel like when I watched the piece that they brought this guy on to take a beating, right? Which is popular in news channels. Like, there's lots of the major networks, CNN, Fox, MSNBC, who bring on like a commentator from the other side of an issue that is going to come in and get like slaughtered, but like look kind of good doing it. Like, that's the vibe they look for a lot of the times. And it's okay. It pays well to take those gigs and take a beating, right? Like, that's fine. It's probably what's going on there. But I just want to specify, like, I'm not underwriting any of the arguments he's making. But he is correct in one thing, which is really, he's just saying, hey, the EEOC director said this. And the EEOC director is correct. Because in many ways, the EEOC director has some power to clarify and speak upon Title VII. That is her role, right? That is her job. Now, Title VII says what it says. You can't be the EEOC director and make up nonsense about what Title VII says. It's neither here nor there. You can't go off book and be like, well, I'm not an elected official, but I'm going to rewrite this law. That's not how that works. But there is like an interpreting role for the EEOC director, where the EEOC director could clarify some confusing point in Title VII. This was not a confusing point in Title VII, but it is a point tied to Title VII, which corporate America has been confused about for a long time, where they will just fundamentally say things that are not true. And they're saying things that are not true because, like, the internet tells them to. Like, the internet will lie openly about this. You will find more content lying about this specific topic, like straight up misconstruing the law in this area, than you will find correctly quoting Title VII or even amplifying the words of the director from the EEOC. Like, that's, trust me, I just ran that Google, and like, there is more wrong content than there is right. And I get why. I don't love the correct answer, right? I'm not excited about this being the correct answer. Doesn't change the fact that it's the correct answer. We can't make up stories about what the law says. The text is the text. And text can be interpreted, but only to some degree. And here, that degree is very little, because the text is very clear. Is what it is. Anyways, I'll link the news story down below. I've found this whole thing to be fascinating. I've been watching this for years. I'm not very used to being called a conservative shill, for obvious reasons. So I always find it fascinating when people are like, you're the whatever. Why don't you go put a white hood on? I'm like, okay. Okay. I mean, I cannot like what the law says, but I still have to tell you what the law says. That's not, I don't get a choice, right? Like, anyways, like, subscribe, comment down below. Helps the channel to grow. Take care, everybody.